District Court. The district courts are the general trial courts of the federal court system. Each district court has at least one United States district judge appointed by the president and confirmed by the Senate for a life term. District courts handle trials within the federal court system, both civil and criminal. The districts are the same as those for the U.S. attorneys, and the U.S. attorney is the primary prosecutor for the federal government in his or her respective areas. District court judges are responsible for managing the court and supervising the court's employees. They are able to continue to serve so long as they maintain good behavior, and they can be impeached and removed by Congress. There are over 670 district court judges nationwide. Circuit courts. Once the federal district court has decided a case, the case can be appealed to a United States Court of Appeal. There are 12 federal circuits that divide the country into different regions. The 5th Circuit, for example, includes the states of Texas, Louisiana, and Mississippi. Cases from the district courts of those states are appealed to the United States Courts of Appeals for the 5th Circuit, which is headquartered in New Orleans, Louisiana. Additionally, the Federal Circuit Court of Appeals has a nationwide jurisdiction over very specific issues such as patents. Each circuit court has multiple judges ranging from 6 on the 1st Circuit to 29 on the 9th Circuit. Circuit court judges are appointed for law by the President and confirmed by the Senate. Circuit court judges are appointed for life by the President and confirmed by the Senate. Any case may be appealed to the circuit court once the district court has finalized a decision. Some issues can be appealed before a final decision by making an interlocutory appeal. Appeals to circuit courts are first heard by a panel consisting of 3 circuit court judges. Parties file briefs to the court arguing why the trial court decision should be affirmed or reversed. After the briefs are filled, the court will schedule oral argument.
Supreme Court of the United States. The Supreme Court of the United States is the highest court in the American judicial system and has the power to decide appeals on all cases brought in federal court or those brought in state court but dealing with federal law. For example, if a First Amendment freedom of speech case was decided by the highest court of a state, usually the state Supreme Court, the case could be appealed to the federal Supreme Court. However, if that same case was decided entirely on the state law similar to the First Amendment, the Supreme Court of the United States will not be able to consider this law. After the circuit court or state Supreme Court has ruled on a case, either party may choose to appeal to the Supreme Court. Unlike circuit court appeals, however, the Supreme Court is usually not required to hear the appeal. Parties may file a right or certiorari to the court asking it to hear the case. If the right is granted, the Supreme Court will take briefs and conduct oral argument. If the right is not granted, the lower court's opinion stands. Certiorari is not often granted. Less than 1% of appeals to the high court are actually heard by it. The court typically hears cases when there are conflicting decisions across the country on a particular issue or when there is an error in a case. The members of the court are referred to as justices, and like other federal judges, they are appointed by the president and confirmed by the Senate for a long term. There are 9 justices on the court, 8 associate justices, and 1 chief justice. The Constitution sets no requirements for Supreme Court justice. Though all current members of the court are lawyers and most have served as one circuit judge, justices are also often former law professors.